Namaskar, welcome to your program Teta Tet. I am Sudhanshu, Ranjan, and we have the proud privilege of having with us Justice Dalveer Bhandari, Judge of the International Court of Justice, which is the principal judicial organ of the United Nations according to Article 92 of the UN Charter. Justice Bhandari has had a checkered career earlier as a judge of the Supreme Court of India, and he is also known for his academic interests, lecturing worldwide in different conferences. So, Justice Bhandari, welcome to our show.
Thank you so much.
First of all, congratulations, you got such huge mandate in the whole world, 122 votes out of 180 that were cast, and 193 are the members of the United Nations, and 13 in the Security Council out of 15. So that's a great honor for the country as well as for you. I would like
It
to
is
know,
really the honor for the people of this country, democracy of this country, the independent judiciary, rule of law. And when I had visited various countries, I realized that people have great respect for our democratic institution, particularly independent judiciary, election commission and audit bodies. So, more than the victory of an individual, it is the victory of the people of this country.
International Court of Justice has 15 judges, and it represents all major civilizations and judicial systems in the whole world. So it has been distributed like this: 3 each from Asia and Africa, 2 from Latin America, 5 from Western Europe and other countries, and 2 from Eastern Europe.
The whole process is governed by Charter of the United Nations, which was signed on 26 June at San Francisco in 1945. Thereafter, it was amended on 17th December 1983, and thereafter on 20th December 1971. Now, according to that, the International Court of Justice is a principal judicial organ of the United Nations. Now, to resolve the dispute amicably, this institution was created. Idea is that all the major legal system and judicial system must be represented before the International Court of Justice. That's why we have 15 members from all over the world, and there cannot be 2 members from one country.
But what is the role of developed countries like USA or these 5 members of the Security Council, permanent members of the Security Council? Because it is assumed that these 5 countries have a decisive role in all the international matters.
You may be right as far as General Assembly's functioning and Security Council functioning is concerned. But when it comes to International Court of Justice, there is a total equality whether a member is from the United States of America or from a small country in Africa or Asia. They have a same voice, the nature of functioning is the same, and they are treated exactly on the same par like any other country.
The International Court of Justice is the new avatar of the previous Permanent Court of International Justice. After the Second World War, it was created as the League of Nations was.
Happened is that after First World War and Second World War, when we had seen so much loss of human life and human suffering, United Nations was created.
First League of Nations.
Correct.
It was succeeded by the United Nations. Similarly, the International Court of
And
Justice was
that's right.
preceded by the Permanent Court of International Justice. But what I have read that there is hardly any difference in the functioning of the 2 courts. Everything remained the same.
As far as nature of functioning is concerned, what you say is correct. It's really not much different. But work has changed from time to time according to the requirements of the various nations. In the earlier period, the quantum of work before International Court of Justice was not very much, but of late work is increasing. The compliance rate of the judgment of the International Court is also increasing. Though there is no enforcement agency for compliance of the judgment, but of late it has been seen that member nations who refer the matter to the International Court of Justice, they usually comply with the judgments.
It's quite heartening to know that there is a high rate of compliance, because what we have read that international law doesn't have any binding force. Its moral authority is what counts, because even the violator of the international law, whichever country violates the law, tries to convince the international community that it has not violated. So there lies the success of the international law. But this is also the
You're
Achilles
right.
heel. If they
Before-
don't comply, you can't do anything.
Before the court, the situation is that they would like to present their point of view very effectively, that they are not at fault, and it's the other side which is at the fault. But once a decision is made, by and large, those decisions are respected and complied with by all nations.
That's quite good, really encouraging to hear these words. But as you
There
said,
have been some exceptions, but by and large, of late, the trend has been a much greater compliance of the judgments and orders passed by the International Court of Justice.
but if someone doesn't comply, you don't have any power of contempt. As you said, that there is no agency to implement or enforce
At
the
times in
order.
past, it was seen that security councils were approached for ensuring compliance by placing some economic sanction and other things, but that may not really apply to a very developed nation. But by and large, the judgments are complied with, and the rate of compliance is increasing.
What about the impartiality of the judges? Because after all, it's the political lobbying made by different countries for the election of their candidates. For example, you were elected when a vacancy was created because the judge Khashoggi was made Prime Minister of Jordan. Now, a sitting judge who is made Prime Minister of his country, if the matter pertaining to that country comes before the court, and then there is no necessity to recuse, as it happens in India, that if there is a conflict of interest, the judge has to recuse. Generally, they do recuse. In the ICJ, they don't.
No,
So do you find any conflict of interest if it so happens?
There is no conflict of interest of such, because once you are elected as member of the International Court of Justice, nationality is not important. You are a judge of the World Court, and you have to act independently, impartially, and that is the solemn declaration which you have to take before you start functioning.
No, that is
as a
exactly
judge.
what I wanted to know. For example, Khashoggi, who vacated his post to become the Prime Minister of Jordan. So if he is nurturing political ambition, is it expected of him that he would be totally impartial, objective?
No, when the question of deciding the dispute between two nations are concerned, the personal ambition perhaps may not really be that relevant. But when this kind of position was made available to him, he resigned and joined that. I don't see much conflict of interest in that sense. And there is a provision of ad hoc judges in the International Court of Justice. A country which has a matter before the ICJ and does not have any member who belongs to his own country, then in order to ensure that there is total justice, that country is given an opportunity to appoint an ad hoc judge for that particular case, and that ad hoc judge will also has to take oath, that is solemn declaration, the same manner, and for that particular matter he would function like any other member of the International Court of Justice.
As there are two Indian judges,
Yes,
like P.V. Jeevan Reddy and M.C. Chagla.
this is done as a routine. Opportunity is given to that country which does not have the representation in the International Court of Justice, and ad hoc judge is appointed, and he would remain there till the conclusion of the entire case, and he would be treated like any other member of the court.
Again, coming back to the same question of election of judges, as you said that if there is no representation from a country, then ad hoc judges are appointed. The very concept of this kind of election is based on the root Fillmore plan that was given in 1920. I would like to know more about it. What is that root Fillmore plan that was given in 1920?
As per election to the ICJ, as I mentioned to you earlier, is governed by the Charter of the United Nations. Now, there is a lot of misconception about it, how judges are appointed. Now, I like to enlighten you a little bit about on that. According to that, as and when a vacancy arises, the Secretary General of the United Nations writes 3 months in advance to the national group in the Permanent Court of Arbitration, and that national group consists of most eminent people in the field of law and judiciary in that country. For example, in our country, the national group consists of former Chief Justice of India, Attorney General of India, and senior most lawyer who has very wide experience in the field of international law as member. Now, they nominate a person on the request of the Secretary General of the United Nations, and when that nomination is sent to the United Nations, then election takes place in the General Assembly and Security Council simultaneously, and one has to get absolute majority both in the General Assembly and the Security Council in order to be elected. So, when it is said that a person is appointed by the government, the whole process is different. Whole process is at the request of the Secretary General of the United Nations, the national group, which is quite independent, though is appointed by the government, but is quite independent and consists of the most eminent people in the field of law and judiciary. They do it.
It's very good that you have clarified this point, because there is general misconception. In fact, people don't know much about the functioning of either the ICJ or the way judges are elected. So it's very
because
good that
for 22 years,
yes,
India had no representation. As a matter of fact, India really got one effective tenure of Dr. Nagendra Singh.
he was just there for 16 years.
9 years, and he was re-elected. He remained the president of the ICJ, and during the second tenure, unfortunately, he passed away, and in the remaining tenure for about 2 years, Chief Justice Pathak was elected as the judge of the International Court of Justice. That is really the only tenure India has got since independence, and thereafter this would be a longer tenure. Otherwise, a country of 1.2 billion people with such an advanced legal and judicial system.
So that again raises the question, when it is said that all the major legal systems and civilizations are represented, and the largest democracy doesn't have any representation for 22 long years, that also raises questions about its constitution setup.
Because at particular time, how much interest that particular nation has taken in ensuring that representative of his nation is elected. So, there are various factors which would really reach to the conclusion, and at times this also happen in one particular reason. One judge has been appointed, then a chance is given to another.
Justice Bhandari, it's really good that you clarified the position, because there is a misunderstanding that the government of India nominates and then lobbies, and some articles appeared in the newspapers that it's not good for the health of judiciary.
The nomination is by the national group.
Yes, yeah,
And
said that.
the Secretary General directly writes to the national group, and national group sent the recommendation to the Secretary General.
Yes.
And on that basis, the election takes place, and thereafter the candidate has to face the election. where all the members of the United Nations, 193, will participate in General Assembly, and all 15 in the Security Council.
So that is what I said, that there is a misconception,
Yes.
because some articles appeared that if a
That's
sitting
correct,
judge is nominated,
because-
government lobbies for him,
because
it's not
for a
proper.
long
And
time-
even about Justice Pathak, the same article said that it was a kind of quid pro quo, because in the Bhopal gas case, he gave a judgment favorable to the government, and then he was nominated for the
So-
post.
And another aspect is the national group can nominate 4 persons. 2 of them have to be from that very country, and 2 can be from other different countries. National Group of India can nominate somebody from South Africa. They can nominate somebody from Australia. So, national group is totally independent as far as nomination is concerned, and that nomination goes to the Secretary General, and Secretary General on that basis would put that candidate in election list, and he has to face the election then. So, it is a nomination and election both, and as is called as a mother of all election. There is hardly any election where 193 countries of the world participate for one position.
That's why it is the most democratic body in the whole world. We shall have a short break right now. Please stay with us.
उठा भाई, बैठ जा बेटा तराजू पर। लाला जी 15 किलो गेहूं तोल दो। पहले इसे तो हटाओ, बाट कहाँ रखूं? पूरे 15 किलो का है, तौल लो। मुझे क्या बेवकूफ समझा है? और ये जो तुम ईंट पत्थरों से सामान तोलकर ग्राहकों को बेवकूफ बना रहे हो, उसका क्या?
ध्यान रखें कि मापतौल विभाग द्वारा प्रमाणित बाटों का ही इस्तेमाल हो। यदि ऐसा नहीं है तो फौरन शिकायत करें। मापतौल से हटा ध्यान, मेहनत की कमाई का हुआ नुकसान।
Welcome back. We are talking to Justice Dalveer Bhandari, Judge of the International Court of Justice, The Hague. So, Justice Bhandari, you have given detailed information about the process, judges are elected, and so many other things you have talked about. Now, again about the functioning, the whole court sits, it doesn't sit in division as it happens in our Supreme Court or High Court. So, all the 15 judges sit, and if there is some absentia, for example, some judges are not available, the minimum quorum is 11. 11. So, what do you find, because you have worked here in the Supreme Court where court sits in division, there the entire court sits, what's the difference?
The main difference is the quantum which is tackled by the Indian Supreme Court is perhaps the highest in the world. Turns out so many cases, but functioning here is entirely different. Here, for every matter, the entire court sits. Thereafter, every judge is supposed to write a judicial note, which is almost like a draft judgment written by each one of them, and that judgment is evaluated, scrutinized, criticized by other 14, and the process goes on for 2-3 days. So, every word which is written in the judgment is read, understood, appreciated by all other judges, and then a drafting committee is appointed, and drafting committee is also elected by a secret ballot to write that particular judgment. And after the drafting committee prepares that judgment, again it comes back to the 15 judges. They scrutinize every word of it, and sometimes pointed out a particular point has not been highlighted, particular point has not been taken, another point has been overstressed. Then again the judgment is modulated by the drafting committee, and then a final draft comes to the court. Again, thereafter, if somebody wants to write a dissenting opinion, he is free to write dissenting opinion. If somebody wants to write concurring opinion, He's free to write concur.
But he has to write. He will not simply write agree.
So, there is a far greater and in-depth study involved in the functioning of the ICJ in every case.
As you said that Indian Supreme Court is different in the sense that the judges have to do maximum work. Perhaps the maximum number of cases come to the Supreme Court of India in the whole world. But since the court sits in division, there is a total erosion of judicial collectivism, so many divergent views you find. And that's why Frankfurter has suggested long back at the time when the constitution was being framed that the court should not sit in division. It should be the entire court.
That's why in America, as you know, the entire 9 judges sit for every matter, because then you know the views of the court as such.
Another thing is that in the International Court of Justice, the precedent is not binding. Why is it so?
Each case is decided on its own facts. Facts are very important, as you must have known.
No, but if in similar circumstances, the ICJ
International Court of Justice is a court of first instance, and it's also court of the last instance. There is no further appeal. And so, as a court, a very in-depth study is done as far as facts of the case are concerned. And when the facts become so important, then it really cannot be binding precedent. Binding precedent is virtually on the law point.
No, if in similar cases, similar circumstances, the court comes to a particular conclusion, and in this case you find that a case of this nature had been decided earlier, then that precedent should be binding.
But I tell you, it has just come where 2 earlier cases of the boundary dispute of the same nation were decided. For example, we have boundary dispute with Pakistan, we have boundary dispute with Nepal, we have boundary dispute with Burma, but the facts would be different in all cases. Therefore, in every case the same exercise has to be done, because one particular case dealing with India and Pakistan cannot be made applicable for India and Nepal or India.
Facts may be different, but the principle is the same.
No, principle is decided predominantly on the basis of facts, because in the apex court elsewhere facts are not that important, because they decide on the principle of law. Here facts are so important, and facts of 2 cases are never similar. Therefore, as a rule, earlier judgment are not binding, they have persuasive value.
Yes, persuasive value.
Persuasive value is always there, but they are not binding as we have in our court, where on a one particular point of law, if a court has already decided, then all cases have to be governed accordingly.
What about the removal of judges? Because it is only by the unanimous vote of the rest of the judges a judge can be removed. So, has it ever happened in the International Court of Justice?
Not to my knowledge, where all other 14 judges must unanimously say that a person is not competent to carry on as a judge of the court.
What are the grounds? For example, we have proved misbehavior or incapacity, that is the ground in India for removing a judge of the High Court or of the Supreme Court. What is the ground to remove a judge?
The ground would be the same.
Same.
But there has to be unanimity among all the other members that a judge has conducted in such a manner that he should not remain on the bench any longer.
It has never happened so far.
To my knowledge.
The International Court of Justice is considered the guardian of legality for the international community, as was decided in the Nicaragua case. So, if it says that it is the guardian, then it must have some binding value. Again, coming to the same question, whether it is just the moral authority.
On the particular point of the international law or the interpretation on a particular treaty, convention, that becomes the final. But a judgment as such will not have that binding precedent as it would have in India.
Again, the jurisdiction of the International Court of Justice is called the contentious jurisdiction. The parties to the dispute have to bring the matter before the court. And if one party doesn't, it cannot be entertained. Though sometimes in Corfu case it did happen between UK and Albania, because it was inferred from the subsequent letters given by Albania, though earlier it was brought by UK. But in the East Timor case, the ICJ refused to entertain whether Indonesia had treated East Timor properly or not, because it was a unilateral application by East Timor.
In most cases, they take preliminary objection. The court has no jurisdiction to deal with the matter. Even that has to be first determined by the court. The way it is done here, the same manner in a very big way. But you're right, the matters can be taken when it's referred by both the member states to the International Court of Justice.
Can it be done by an individual also, or it is only country that can take the matter to the ICJ?
Unless that member is of that country, it would be at the discretion of the ICJ whether to entertain it or not. But ordinarily all cases which come before the ICJ are referred by the member nation of the United Nations.
Last question, in this brief period that you have with the ICJ, what is the most contentious case that has come before you?
Actually, as you know, that I had taken solemn declaration, which is called oath here, on 19th of June, and I could not be part of the earlier parted matters. So I would be taking up the new matters where I'll be there in all the cases now from September onwards.
But why the need of parted? Because when the court, entire court sits, it's not in division.
Because where I was not the member, where it was heard by the other 14 members of the court, if I join that, it would be difficult. So I can't be part of those cases. So I'll be part of the cases which will start from September onwards.
Okay, Justice Bhandari, thank you so much for talking to Doordarshan. It's a pleasure talking to you. And viewers, thank you so much for watching this Tete-a-Tete.